litigation, including construction law, professional regulatory law, and insurance law. She's a graduate of the University of Saskatchewan in 2010 with a Bachelor of Science in Pharmacy and received her doctorate from the University of Saskatchewan in 2016 and was called to the bar in 2017. She has appeared before the Saskatchewan Provincial Court, Saskatchewan Court of King's Bench, Saskatchewan Court of Appeal, and Alberta Court of Appeal. Please help me in welcoming Janelle.
Thanks, Ian. Good morning. I'm assuming you can hear me okay?
We can hear you. Yeah.
Perfect. Not so great with technology, so I always am a little worried. I'm just going to share my screen here as well to bring up the presentation. And if something goes wrong, I'm hoping, Ian, you can jump back on and let me know that it's not showing the presentation. But so as Ian said, I'm Janelle Souter from MLT Aikins. I've been asked to speak this morning about liability risks and insurance considerations for agrologists. So switching gears quite a bit from our last presentation. As Ian mentioned, I am with MLT Aikins, which is a law firm that has offices across Western Canada. I do practice a wide range of civil litigation, primarily construction law, insurance law, and professional regulation. With respect to insurance law, there are two main areas that I practice in there. One is with respect to coverage issues. So, is a particular situation covered by an insurance policy? The second area is where there is coverage under an insurance policy, and the insurer is involved either in the defense of a civil claim or is bringing a subrogated claim on behalf of the insured. And in those situations, will represent the insured and the insurer in those legal actions. Starting off with liability risks, which may face agrologists. It's a particular hazard of my profession, but lawyers see risks everywhere. And this is why we get paid. Nothing is without risks. But the trick is not just to identify the risks, but to figure out a way how to mitigate or control those risks so you can move forward. And one of those ways is through insurance. Now, agrology captures a pretty broad set of practices. You have agrologists that work in like soil sciences, for instance, other agrologists that deal with pest management, agrologists that are educators, agrologists that are plant breeders, and not all agrologists will have the same risks. Because of this, it's important for you as an agrologist to take a look at your own practice and identify your risks. It's also important to get a good insurance broker and talk through what your practice is, where you see areas of risks, where your broker sees areas of risks. Insurance brokers get paid. And so find a good broker, have them work for their commission, and get the right insurance policy that works for you and your practice. It's not going to be a one-size-fits-all situation. The type of risk and the amount of risk will depend on your practice area. Like I said, there's a wide range of practice areas. It's going to depend on whether you're an employee, are you an independent contractor, are you a business owner, do you have your own employees? All of that will have different levels of risks. If you're an employee, sometimes your employer will also have their own insurance policy, and it may be that you're covered under those policies. So those are some questions you want to ask and want to know. As a business owner, you want to make sure to have policies in place that cover not only you, but cover the actions of your employees, which you may be held liable for. You want to take a look at things like the information that you hold or that you deal with. For instance, do you hold sensitive personal information of your clients, like, for instance, their financial information? If so, that's going to make you more at risk if you are the victim of a cybersecurity attack. Do you hold confidential information or trade secrets? Other things you want to consider are the services you offer. Do you primarily just offer advice and just advise your clients? Do you sell goods? Do you invent goods? Do you make goods and distribute them? So all of those will have different types of risks. And lastly, the jurisdiction of practice. So if you only practice in one jurisdiction, so if you're only practicing in Saskatchewan, it does make things easier. But in this type of world, often people are practicing in different jurisdictions. And if you're practicing in multiple provinces or multiple countries, there are going to be different laws in place in those different jurisdictions. And because of that, there are going to be different risks. So the object, though, is not only to identify those risks, but to identify them and find a way to balance them or control them. And the focus of this presentation is insurance policies, but I did just want to take a quick second, a bit of a detour to talk about contracts. The risk you face can increase or decrease depending on the contract you enter into. Contracts may have limitation of liability clauses, which may limit the amount, which may prevent someone, for instance, from bringing an action against you for certain occurrences, and it'll limit your liability, exactly what it sounds like. There could be indemnity clauses where the person you are contracting with agrees to indemnify you if something goes wrong and someone brings an action against you. But on the flip side, there may be provisions that increase your risk or increase your exposure if something goes wrong. You could be the one agreeing to indemnify the party, or you could be the one taking on more risk in the insurance contract. So, all of this said, there is no magic bullet. There's not going to be a contract that's going to save you from every risk. There's not going to be an insurance policy that's going to protect you in every situation. It's just about finding a balance and finding invoking different strategies to make it so the level of risk is acceptable and you can practice agrology comfortably. Now, we all like to think that we are perfect, but the fact of the matter is that we remain humans and humans make mistakes. And because you are a professional, you're held at a higher standard. And if you make a mistake, the door is open for professional liability or professional negligence claim. Other legal claims can also be brought in various causes of action. There's defamation, breach of contract, trespass, other torts, and so on. And we'd like to think that we live in a world where people aren't overly litigious and people aren't bringing legal actions frivolously. But that's not always the case. You could have a situation where you've done nothing wrong, but you could still be drug into a legal action and be forced to defend yourself or defend your company against a claim that there really isn't a lot of merit in, but still is going to cause you to have to spend money paying a lawyer and incurring legal fees. Other risks could include business interruption due to things like fires, floods, pandemic. There's the growing risk of cyber attacks and data theft, property damage through your own fault, the fault of your employees, the fault of a third party, the risk of crime committed against you, the risk of personal illness and death, what happens to your company if you become too sick to work. If you're an employee, what sort of short-term or long-term disability insurance do you have through your employer, and is that going to be sufficient? Now, as I mentioned, you're not going to find an insurance policy that's going to cover 100% of all situations you're going to face or 100% of these situations. You just need to find one that covers enough risk that you feel comfortable practicing. So moving forward to types of insurance coverage, there are two main types of insurance coverage I would like to focus on. The first is professional liability insurance, which is also called errors and omissions insurance. The second type of insurance is commercial general liability insurance, which is often referred to as CGL, a CGL policy or CGL insurance. Professional liability insurance and commercial general liability insurance protect you from claims that are brought against you by another party. But the two types of insurance have different focuses. Professional liability insurance covers negligent acts, errors, or omissions arising from professional services. So, mistakes you make as an agrologist providing agrology services. It's not going to cover non professional activities. And this is where commercial general liability comes in. So commercial general liability policies protect you against claims arising from non-professional activities and regular business operations. And it generally covers property damage or bodily injury to others if you become legally obligated to pay damages. common provisions in both CGL policies and errors and omission policies will include a duty to defend provision. So this provision will require the insurer to step in and defend you if a claim is brought against you, assuming the claim falls within the scope of the policy. Usually this duty to defend will apply to civil action. So if someone starts a claim against you in the Court of King's Bench, saying that you were negligent, and because of your negligence, they incurred certain damages and they're seeking those damages against you. It depending on the policy, it may or may not cover regulatory proceedings. And I raise this because as professionals, you are under the governance of the Saskatchewan Institute of Agrologists, and it may be that somebody makes a complaint against you for professional misconduct or professional negligence. And not all policies will cover regulatory proceedings, so that's something you should ask your broker. Another thing to note is if the insurer has a duty to defend, generally the insurer will also have the right to choose legal counsel. And sometimes this could be a sticking point for people who've always used the same lawyer and would want to use the same lawyer again if they have an action brought against them. And sometimes insurers will work with you if you have a preference. Sometimes they'll cover a certain amount of costs and get you to cover the other costs, or sometimes they accept your suggestion. Other times, insurers will have their preferred counsel or will have financial arrangements with certain lawyers and will want to work with those lawyers in defending the claim. But usually, and you'll hear me say this so many times during this presentation that you're going to get annoyed with this, but you're going to want to read your policy to see whether it speaks to that. But generally speaking, with the duty to defend, there's also the right of the insurer to choose who is going to be representing you in a legal action. Both CGL policies and errors and omissions policies will include provisions providing that the insurer has a duty to indemnify you with respect to any awards made against you in the claim. So if there's a legal action and the judgment is that you are liable and you have to pay a certain amount, there's generally a provision that where the insurer is going to pay the amount of the award, or if it settles before there's a decision, that the insurer will pay the settlement. But there may be situations where the insurer has a duty to defend, but not necessarily a duty to indemnify you. And this generally arises where a claim is brought in multiple causes of action, and only some of those causes of action are covered by your insurance policy. So if an action is brought both in professional negligence, which is covered by your errors and omission policy, but also alleges fraud, which would not be covered by an errors and omission policy, it may be that because it arises from the same factual situation, the insurer will cover the duty to defend. But if the decision comes out and you're successful with respect to the negligence claim that is brought against you, but are unsuccessful with respect to the allegation of fraud, and your insurance policy doesn't cover fraud, your insurer would have no requirement to indemnify you with respect to any award that isn't within the scope of the insurance coverage. When you're looking at insurance policies, so errors and omissions policies or CGL policies, there are a few provisions that I'd recommend you take some extra time reviewing or specifically ask your broker about. The first provision is to take a look at the policy to see whether the policy is a claims-made policy or an occurrence-based policy. A claims-made policy will cover incidents that occur and are reported during the policy period, so when the policy is active. An occurrence-based policy will cover incidents that happen during the policy period, regardless of when the claim is reported. So there are pluses and minuses to both, but you should be aware in Saskatchewan, the usual limitation period is 2 years from the date of discovery of a cause of action. So a mistake could have been made in 2026, which might be professional negligence, which caused your client damage, but the client or that person may not bring a claim against you for another 2 years. And so you want to make sure that you have coverage for that entire period and you don't have any gaps of time where you don't have insurance coverage. And this should also be a consideration for retiring agrologists. If you've always had professional liability policies that were claims made policies, you might need some tail coverage for later claims, even though you're no longer practicing. The second provision you want to take a look at are the coverage limits. How much will your insurance policy actually contribute if a legal action is brought against you? And there's no magic number as to how much protection you need. Again, it's all going to depend on your risks. Are you working on projects and providing advice where if you make a mistake, there are hundreds of millions of dollars at stake if something goes wrong? Or do you work on a smaller scale and not as much as at stake if an error is made? Um, the more coverage you have, the more expensive your policy is going to be. So as always, it's going to be a balancing act, but it's something you should talk about with your broker. And generally, we do recommend you have at least a couple $1 million of coverage. Things add up quickly, but you may need more coverage than that if you're working on some pretty high stakes projects. The next provision that you're going to want to pay some extra attention to is what the policy scope is. What's included in the coverage? Who does it cover? Where, like, what time period does it cover? What jurisdictions does it cover? So what's included in the coverage? Is it just negligence? What about other torts such as defamation, trespass, other torts like that? Who is it covered? Does it just cover you? Does it cover your employees? Does it cover contractors you bring in to do work for you? Is it just for incidents that occur in Saskatchewan? What happens if you're practicing in other jurisdictions? And what time period is being covered by the policy? The last one is the big one, and it's what's excluded from your policy. And there's usually a long list of situations that are excluded from coverage or a couple of provisions that talk about exclusions. And I would recommend that you take time to read through those. As painful as it is to read through insurance policies, you need to read through the insurance policy before you buy it and before it becomes an issue. And it's extremely common. It's I can't tell you how common it is to have a client come in and say, "This happened. I thought I was covered, but I'm not sure if I am or not." And people just don't look at their policies until a claim is made against them and they need to rely on their policy. And that's not the ideal time to learn that you thought you had insurance coverage for something and it turns out that you don't. So take the time to walk through the exclusions. If you have questions about what's covered and what's not covered, again, take the time to talk to your broker and figure out what you actually have coverage for so you can make an informed decision as to whether that's the policy you want to go to and you know what your risk level is and what sort of risks you might be subjected to. So CGL policies or professional liability policies generally just cover claims that are made against you or your employees for depending on the CGL policy. You will need coverage beyond those two types of insurance, particularly if you are running your own business. Um, they're so generally not covered by a CGL policy or professional liability policy are injuries sustained while on the job to you or your employees. Saskatchewan does have a compensation scheme that's pretty good and perhaps your business is a part of. But there are carve outs to that scheme, and it may be that you are one of the carve outs and you're not covered by the workers' comp program or you're not part of the workers' comp program. And if you have employees, you should look at other forms of coverage. CGL policies or professional liability policies generally don't cover vehicle accidents or damage caused by automobiles. And if you're using a vehicle for your business, we usually recommend getting coverage beyond the plate coverage that's covered by SGI or provided by SGI. CGL policies and professional liability policies aren't going to cover damage to or theft of your own property. It only covers the damage property of others who then claim against you. So if your property gets damaged by yourself or your employees or another third party, it won't cover those costs, and you would need a different like a property insurance policy to deal with those sorts of risks. It's not going to cover your own business interruption costs. CGL policies and errors and emissions policies aren't usually going to cover employment issues. If you have employees and then there's allegations of harassment or discrimination or other employment issues, usually those are carve-outs as well. So you want to be aware of whether that is covered or not covered in your policy and whether you need other insurance for those issues. And it's very rare. Some CGL policies may have an endorsement for cyber attacks, but it's pretty rare for the policies to cover cyber attacks or have a cybersecurity endorsement. And again, this is becoming a pretty big risk, and it can be very expensive if someone hacks into your system and either steals personal information and uses that information, or if it uses your system to conduct fraud against others. I'm sure you're all aware of there are a number of situations where a bad actor has hacked in and can send emails that look like emails that are coming from your system or may actually be coming from your system if they have hacked into it. And if it causes damage to somebody, again, they could bring a claim against you for that, and it may lead to additional expenses for you to increase your own IT and deal with the cyber attack. And oftentimes there is a ransom that's associated with the bad actors. They'll hack your system and then demand some sort of ransom. And if you don't pay the ransom, that they'll distribute the personal information on the dark web. So again, if you're doing something that's particularly sensitive to cyber attack, you may want to look into cyber insurance because it's generally not part of the CGL policy. But again, take a look at what your policy says. As an insured under a policy, you do have obligations. The biggest obligation, or one of the most important obligations from my perspective, is the obligation to provide adequate notice. People have a tendency to want to ignore mistakes, or they want to ignore an unpleasant situation, but nothing is to be gained if you bury your head in the sand. If you know you're at risk of a claim being made against you, or if someone has actually brought a demand, reach out to your insurance broker, provide them with notice, give them a heads up this is happening. And it may not be time yet to make an insurance claim, particularly if they haven't brought a statement of claim yet. But ignoring what's happening to you will do you no favors, and you do want to give your insurer notice that something is happening. Usually sufficient, you want to provide enough notice that the insurer can't say that they face some sort of prejudice and were unable to defend you properly because they weren't given sufficient notice of what was going on. So that's kind of where that all arises from. If the insurer does have a duty to defend you in a legal action, you have a duty to participate in the investigation and also to cooperate during the defense. Because the action is still being brought against you or your company. And even though the insurance is involved in defending it, they're paying the lawyers, they're instructing the lawyers, you're still a party to that action and you have obligations as part of the action. You may have to go through a questioning, you may have to attend the mediation or the pretrial conference, or you may have to testify in the action itself. And you do have an obligation to participate in the defense so the insurer can properly defend you. You can't just pass it off to your insurer and say, it's your problem now, I wash my hands of this. I'm not paying if there's an award anyhow, so it's your issue to deal with. They can deny coverage if you aren't properly cooperating. There usually is a duty to mitigate damages. What that looks like depends on the situation. There's the easy ones are with like property coverage policies, where if there's like a fire or a flood or something like that. It's to make sure more property isn't damaged that doesn't have to be. So removing items from the flooded area, or making sure that cleanup occurs, things like that. So what that looks like depends on the circumstance. The last one I wanted to flag is you have an obligation not to make misrepresentations to your insurer. And it generally comes up in two main situations. The first is when you're applying for your insurance. You want to make sure the representations you make on your application are accurate and there are no misrepresentations there. It's also true when you're making a claim. You want to make sure you're not misrepresenting facts to the insurer with respect to what happened, or the amounts being claimed. And not all misrepresentations are fatal, and sometimes some are unintentional. But if it is a material misrepresentation, it could void in insurance coverage. So you want to make sure what you are telling your insurer is accurate. To wrap things up, I did also want to highlight the SIA bylaws that address insurance coverage. Specifically, bylaw 21 speaks to professional liability insurance. 21.1 provides that prior to providing independent agrology services, an agrologist shall, so that's mandatory language. So an agrologist must notify the client in writing that they have professional liability insurance that applies to those services to protect the public interest. 21.2 says the council may take steps to ensure all agrologists declare they are covered by insurance with respect to professional liability claims to protect the public interest. And as a professional, you should be aware of your professional obligations. So if you haven't read the bylaws in a while, I would recommend you take the time, read the bylaws, confirm you understand what your professional obligations are. So a bit of homework. First, you have to read your insurance policy, which is not a ton of fun to read, and I can say that as a lawyer that reads a lot of insurance policies. And your second step for homework is to read the regulatory bylaws and the SIA bylaws to make sure you understand what your professional obligations are under there. So I burned through that presentation pretty quickly, which is easy to do when you're just talking to yourself. So if there are any questions, I can address those.
Thank you, Janelle.